Adrian, what do you think about, how do you think the enhanced role of restructuring professionals in the new regime, particularly in the context of a rehabilitation procedure, how do you think that might make a difference?
Well, I think that for all of this to work, you do need a cohort of experienced insolvency practitioners. I think in the European Directive, one of the requirements imposed on EU members is to have a procedure which involves practitioners experienced in the field of restructuring. So there's a key there, which is keyword, which is experience. Most people who go into business, everyone who goes into business does so in order to build a successful business, to make money, to build something for their stakeholders. They don't go into business because they're interested in trying out rehabilitation or administration.
No matter how good it is.
Which is a shame. But as a consequence of that, I mean, unless they've had the unfortunate experience of having gone through it before, they're not going to have necessarily the skill set of managing stakeholders and the process in the most optimal way. And so that's why the role of insolvency restructuring practitioners is really important to actually make this work. And so along with the law, one hopes there's a sort of public awareness and some sort of advocacy of the need for practitioners to assist management in these situations. And the earlier that you get practitioners involved, the more the greater likelihood is of success, because that means that the problems that a business has can be properly diagnosed and addressed. And also, the earlier that you speak to stakeholders, the more likely you are to gain their confidence, rather than presenting them with a car crash very late in the day. It's much better to have got them involved earlier on and hopefully avoid the crash.
For recoveries and mental health.
I can probably add to that. I think that it's probably most specialized in terms of restructuring, because although we are insolvency and the law looks at insolvency practitioners and now I think administrators as well, it's kind of extended that definition and gives the same powers. But it is definitely more specialized. I mean, I attend a lot of conferences globally on this kind of subject, and people who are more restructuring specialists, they have hands-on experience of actually running companies and seeing what are the issues and taking decisions. Probably we guide them. Probably Adrian and I will be more as a role in terms of overseeing that. But the restructuring specialist is more hands-on and actually knows how to deal with even day-to-day issues, how they will respond and tackle matters as they come along, because that's what's required in that kind of scenario. It's not like a superficial exercise that you just do the contracts and you kind of manage the legal process. It requires that extra bit. So there will be interest, because I'm sure there are specialist firms globally that actually just do that. So it will be a combination of building these kind of teams that will actually come to deliver this in the context of DIFC.
The other thing is, just in terms of judging the law as well, there's also the procedure which isn't in the law, which is informal restructuring outside of the law. And one of the successes of a law is its normative impact. So it's not necessarily actually using the law, it's the fact that the law is there, it's the kind of messaging of the law, and the fact that people know that it's there, that they can use it should they need to. But if you've involved advisors, appropriate advisors at an early enough stage, you may well be able, as indeed is often the case, you may be able to drive your restructuring without actual recourse to the law, that the law, if you want, is there as your sort of plan B. If people are going to be difficult, you've got ready avenues to deal with that.
I think it also provides a framework, doesn't it, against
Yeah.
which that out-of-court restructuring can be negotiated.
Exactly.
Out-of-process restructuring,
Exactly.
it gives a
Yeah.
backdrop, a paradigm structure.
Yeah.
And just to add to that, I think that if you look at the UK, as you said, UK has administrative things, it's not debtor friendly, but you see there's an increased use of CVA where actually it allows these kind of voluntary arrangements to
Yeah.
give a better outcome as a whole, because it's done by agreement.
And you've got the, as I mentioned, you do have the scheme of arrangement, which is a company law procedure. It's not an insolvency procedure. It's much lighter touch. So that's also, and that's used a lot in the UK as well.
Yeah, yeah, indeed. Okay, so just to round off, I mean, we've talked about the importance of developing precedent and the importance of developing infrastructure, and there is an element of time for particularly the former of those things. But as a sort of general view, do you think that the introduction of this new regime and the reform of the insolvency law is good for sort of a big picture investment in the DIFC in terms of the sort of goals that Jacques was talking about earlier of the DIFC generally? Do you think this is an important strand in delivering on that? Both of you?
I think certainly that, look, our experience with the DIFC has been very positive because of the framework they've, and it's a kind of breath of fresh air in terms of what it offers in terms of the legal infrastructure, the justice system. And I think it's the vision of the ruler. The ruler of Dubai has specifically instituted DIFC to become a leader in this kind of space. So certainly this is just adding to that. I mean, the question is that they've reformed it and they've benchmarked it. And as we've discussed, they've taken from Singapore best practices globally. And I can see that. That is, I mean, even this, when I was in Singapore, this ipso facto clauses actually helps to conform to what is international best practices. So I certainly believe that it is an avenue, and many people will probably consider DIFC as a jurisdiction, and that's what it's been created for. So if you see, many global businesses have headquartered here, and they continue to look at DIFC. Even contractually, your lawyers, many people use DIFC as the preferred jurisdiction for any commercial disputes. So I think that's by choice, and that allows people to actually have a certainty in the outcome. I think that is the key point, I think, that DIFC offers, and I think it will continue to do so. So I'm very positive about what it does, and I've been an active supporter being here with them, and been quite, and it's been a good run for us.
Adrian, do you have anything else to add to that?
No, I mean, I just sort of, I just agree with everything my learned friend. Absolutely. And just to mention, as I said at the outset of my comments, certainly the approach to the World Bank is to see the existence of credible restructuring procedures as part of a key indicator of how easy it is to do business in a jurisdiction. So yeah, definitely part of the wider framework for the jurisdiction.
And actually, I was chatting to one of the rating agencies recently about this point, and they were very interested in the new regime precisely for that. When they rate corporates and they rate them from a kind of loss given default perspective, just knowing that there's a comprehensive regime there and they've got some visibility about what recoveries might look like, it allows them to give enhanced ratings to jurisdictions in those entities. So
I just want to add one thing else. So I think that issue being that if you look at the Dubai law, the UAE law actually introduced 2 years ago almost, and actually mirrors very much what they. So I think there'll be a lot of learning from what DIFC does, because still I think if you look at Dubai or UAE as a whole, there have been some things of restructuring and things like that. It's not clear really how they've kind of worked out, but certainly DIFC, as Adrian said, there'll be convergence. So DIFC probably might benchmark a lot of this. So it's a question of learning from how we do things or how the DIFC does, and it can actually be shared by a lot of the courts within the UAE.
Yeah, absolutely.
So I think that's actually quite an important point that many practitioners might want to consider.
Yeah, no, absolutely. I think it goes to Adrian's sort of point about the normative influence of the regime. So that's great. So I've been just checking my phone. I haven't been tweeting. It looks like we've run out of time for the panel session, but there's plenty of time for questions from the audience if you have any.
Hi, I'm Saad Maniar from Crow. The DIFC Insolvency Law provides a good framework, definitely for sure. But in the context of the financial services firm in the DIFC, how far and how practical this rehabilitation, chapter, what we have introduced, will be applicable?
So let me answer that. So I think that, as I explained, that look, most of the rehabilitation will work if there's a viable prospect of the business continuing. If there's no business or there's no opportunity, then it will not fall within that context. So at present, most people who come here, although we have insolvency is not, we have a few cases, but it's not that prevalent, because most people who establish here, they actually, even with the DIFC, they have a business plan, they look at opportunities and they establish themselves to ensure there's continuity. But of course there could be unfortunate circumstances and then they have to consider that. But thus far, I think that it will have to be a special case where you see there are some issues with creditors that you will then consider that. But I would see that the size of DIFC will at present not have many of those kind of cases.
In the context, I would like to hear from Adrian. In this context, in your experience, have you seen any kind of financial services firm or the services industry, applying this rehabilitation chapter?
In terms of the DIC, the pre-existing DIC.
Talking about your experience in London.
Jurisdictions.
I see. We've certainly had a number of obviously very famous broker-dealer failures in the London market. Most famously, the British subsidiary of Lehman Brothers, LBIE, Lehman Brothers International Europe, and we've had a couple of other smaller broker. MF Global, yeah, we've had a couple of other broker-dealers which have failed and have made use of, certainly MF Global has made use of legislation which was introduced following Lehman's, which is all around, focuses around protection of client money. In terms of other financial services companies, there have been a number of failures, and in my experience, not many of those have made it through rehabilitation. The focus has tended to be on if they hold client monies, has been really on the winding up of the business and returning client monies rather than preserving the business. So most of the turnarounds, restructurings that have happened in the London market have been really in other areas than financial services, I would say. I'm just racking through my mind now.
I can give an example actually of this financial services. There was a company in Bahrain, Arc Capital, and they actually used Chapter 11. It was kind of a reverse structure because they didn't have a robust restructuring regime. So because they had interest in the US, they could use Chapter 11 and bring all the parties within, and it was successful in terms of that. But as Adrian says, the problem with financial services, because they're high profile, once a reputation comes out in the press, it's very difficult to recover, because whilst they're going through restructuring, there could be the media that has their own thing, they want to sell news, and sometimes it's unfair, because if you look at Arthur Andersen, after all that process of that, the judge says it was wrong what happened to Arthur Andersen, it collapsed. So you'll find that similar stories and other things, that there probably is a viable plan, but because it goes viral on the media and people have certain perceptions, so then it becomes very difficult, because the confidence is shaken in terms of.
So I agree. While we have ticked the box with regards to having the overall comprehensive framework, so what is in it for the financial services firm and the service industry which exist in the DIFC?
But so again, there are early warnings in any business. So once you know there are early warnings, you will take steps to see how you can protect yourself. So in that way, like in the conception of Arc Capital, they knew there were issues and they came to some way of dealing with it and dealing with the creditors. So you have to be, and that's upon the management, because even if you look at the new legislation, it talks about mismanagement, it talks about misconduct, especially in your financial services. If it's misconduct, then it goes through an administrative process. It doesn't go into rehabilitation because of the regulatory aspects of what misconduct was and what was the mismanagement. So there are processes, but obviously you have to manage it as quickly as you can. And of course, there will be cases where probably it's beyond your control because of external environment.
Just a quick word from the DIFC on this. You have to understand that what the DFSA is, the regulator, has certain powers under the regulatory law that are applicable in circumstances like these. And they also have the right to appoint an administrator or a receiver, and they will deal with that specifically, as Adrian said, to protect essentially client interest, client money, client assets. That doesn't mean that because the regulatory law, when it's a financial services firm, the regulatory law and those powers of the regulator take obvious precedence over what we're trying to do here. The two are not mutually exclusive, but as Shahab said, because there's trust involved, typically you won't get to this point. The key thing that you need to remember that in a place like the DIFC, there's about 600 regulated firms, but there's about 2,500 at present that are not regulated, to which this applies. The holding companies that have multi-jurisdictional sort of businesses, operations, and assets. That's what this is meant to apply to.
We've got a question at the back.
I just had a question about the jurisdictional reach or the nexus to DIFC in order to benefit from this law. Now, presumably, if the debtor is a DIFC company or the debt documents are governed by DIFC law, that's an easy case of this law applying. But can parties to a mainland financing consensually agree to use this law, be bound by this law in the event of an insolvency, or does there have to be greater nexus? Or if you have just an SPV in DIFC, but all other assets are offshore, like how does this choice of law play out?
I mean, the law is applicable to DIFC companies.
I've got your lawyer.
The law is applicable to DIFC companies, so you have to be a DIFC company in order to access the legislation. What might be possible is if you have, say, an onshore Dubai company who goes into an onshore Dubai process under the UAE federal bankruptcy law, that office holder could potentially apply to the DIFC courts for recognition under the UNSTRAL model law provisions, which Adrian was talking about, and then potentially access the regime there. I think the practical challenge that you'll have is then if you're seeking to use the regime, for example, to cram down creditors, we'll be exporting that back into onshore Dubai, and I think that's where the challenge, and it goes to Adrian's point about how you need to have reciprocal arrangements with courts on the other side in order for that to be effective.
So, which is different. Like I think for the UK, you can have quite a tentative connection to be able to use a UK scheme of arrangement, for example, so if you have creditors in the DIFC who want to do a rehabilitation, but the debtor is not a DIFC company, that the likelihood of using this law then is not good in your estimation?
I think you would probably have to explore it on a case-by-case basis, yes, because there can always be reasons why jurisdictional considerations are less significant depending on what you're seeking to do. But instinctively, yes, that it's not really designed for those procedures. I think, although I might be wrong, that the reach of a scheme of arrangement covers recognised companies as well as DIFC companies, possibly.
Let me just add to that. In the sense of the new federal law for bankruptcy, actually it allows for these kind of arrangements, but the court has to sanction it, similar to what we have in the DIFC. So if the court sanctions it as a sensible agreement, I don't see any issue in actually coming to a satisfactory conclusion on those matters. So the existing federal law also has provisions to actually come to these kind of arrangements. It's been revised again as with best practice, so they have adopted some of these things, albeit it's a little bit more, again it's court driven, the courts have to do that. The issue we have as yet is that I think they're still trying to grapple with how they will integrate that and how they'll work it out. So it's only a question of time. I mean, the law has been tested, I mean, in this kind, but there are provisions to actually facilitate that kind of structuring.
So when it comes to CVAs and rehabilitation administration, those provisions apply to what's defined as a company, and a company is defined as incorporated within the DIFC. Then you also have the provisions which apply to recognised companies, which are foreign companies, but which have a place of business within the DIFC. Beyond that, you've got the UNCITRAL model law, and that provides for recognition of foreign practitioners. So if the debtor is represented by a practitioner who comes to the DIFC, that practitioner can commence rehabilitation, CVA administration through the DIFC. So in that sense, it is a portal to use the DIFC insolvency law or restructuring law. Then, whether you can then export that, it very much depends upon the recognition regime in the jurisdiction that you're trying to export it to. So I hope that.
Thank you.
My first question was asked by this gentleman too. I was wondering more about the sort of the mismatch between the DIFC law and the onshore law and how sometimes they clash. We had a recent case with Dana Gas where there was a ruling in the DIFC and that ruling was sort of reversed onshore and had this situation that couldn't come to a resolution. So I was wondering, to which extent is it possible to enforce the DIFC decisions onshore? This is one of them. The other question is, how much is the DIFC insolvency law different from the UK law being applicable in the ADGM, and where you can naturally access schemes of arrangement and such?
Okay, so in relation to the first question, I think we sort of touched on it generally. There is a memorandum of understanding between the DIFC courts and the onshore Dubai courts, which provides a route for recognition. I think the concern that sort of generally expressed is that there's a concern about using that route as a sort of conduit jurisdiction, as the phrase that's used, to sort of manipulate an outcome, and that would be the concern with utilising a DIFC insolvency regime and then seeking to export it onto the onshore courts, because you know, I think one of the fundamental differences between the UAE federal insolvency regime and the DIFC insolvency regime, particularly when you're looking at the rehabilitation process, is that the DIFC insolvency regime permits the cram down of secured creditors, whereas the UAE federal regime, it only permits cram down of unsecured creditors. Secured creditors sit completely outside of the UAE federal insolvency law regime. And so, you know, again, I think you would, you know, if you were looking at this in any particular scenario, you would be, you would probably look at it, you need to look at it on a case-by-case basis, taking account the kind of wider facts there. But I would be inherently nervous about taking a DIFC judgment that crams down secured creditors and trying to export that in a meaningful way into the onshore courts, assuming that the reason you're going down that route is precisely to do that, precisely to cram down secured creditors. So that would be the concern there. The ADGM insolvency regime is very similar to an English regime. So it pretty much broadly reflects the English regime. There's some nuances in terms of how some of the sort of clawback provisions and things are developed, and it's always needs to be sort of looked at kind of in the local context. They do have a scheme of arrangement in the ADGM, just like they do have in the DIFC court. So there are some similarities, but the rehabilitation procedure is not part of the ADGM legislative landscape.
Yeah, but I would imagine that they would have to change, because obviously if you look at DIFC, they also had a very similar process, pretty much based on the English insolvency. So they have reformed it to actually bring in. So I would imagine that if ADGM wants to be in the fray, they will have to look at these kind of changes or updates in their law.
Okay, thank you very much for your time. I'll let Jacques conclude. Yeah.
Well, thanks everyone for attending. and for your time and for your interest. And thanks to the panel. We did quite a few of these over the past few weeks with the new legislation, and I think this one was particularly excellent. So thanks for your contribution. Thanks, Adrian, for traveling out just for this, and Shahab and Nicky for your insights. So thanks very much, and hope you have a nice day. Bye-bye.
Thank you.